Welcome to one of the most intense courtroom showdowns you'll ever witness. Today's case involves Danny Eugene McDowell, a man facing multiple life-altering charges, including attempted murder, torture, and criminal sexual conduct. This isn't just another court hearing. It's a psychological battlefield where every word and every reaction could determine his future. You'll see a defendant who completely loses control, a judge who won't tolerate disrespect, and moments so intense they could be straight out of a legal drama. As we break this down, I'll guide you through the critical legal twists, from the shocking allegations of drowning to the jaw-dropping $1 million bond. But pay attention, is McDowell's outburst genuine frustration or a calculated move? We'll dive deep into that. Make sure you stay until the end, because the judge's final ruling is something you won't see coming. So, let's step inside the courtroom and see how this high-stakes hearing unfolds.
All right. Officer, are you going to be conducting probable cause hearing? You going to swear to it?
Yes, Your Honor.
Okay. All right. Saturday, July 15th, 2023, 1:10 p.m. in the matter of People State, Michigan versus Danny Eugene McDowell. Charged with count 1, assault with attempted murder, count 2, torture, count 3, criminal sexual conduct, first degree, during felony, count 4, unlawful imprisonment, count 5, criminal sexual conduct, third degree force or coercion, count 6, assault with intent to do great bodily harm less than murder or by strangulation, count 7, domestic violence.
Did you catch how serious these charges are? Assault with intent to murder, torture, and multiple counts of sexual violence. This is as severe as it gets. In Michigan, charges like this can mean decades behind bars, or even life. It's rare to see so many violent charges stacked on one defendant at the arraignment stage. The courtroom is tense already, and the judge is carefully listening for every detail. What's fascinating is that the probable cause hearing here is more than a formality. It's the first real test of whether the prosecution has enough evidence to move forward. What do you think? Based on the charges alone, would
To 12811 Heritage Drive, apartment 203 on 7/13 at 3:58 in the afternoon for a welfare check on a victim. You can take a step back, sir. Good. Once they arrived, they contacted the defendant, who's in custody, Danny McDowell, and the victim, Faith Allen, at the residence. After speaking with both of them for some time, they were separated. Assault was determined that it happened. McDowell was placed under arrest for domestic. He was transported back to the station. I, as the detective on call, was sent out to the scene, conducted field investigation, conducted interviews. Was found to believe that on Tuesday, a couple of days prior, so it would have been 7/11, assault occurred, including 3 different times where the suspect placed the victim underwater, held her underwater, and at one point on the third assault actually drowned her to the point that she lost consciousness.
This is where the case takes a dark and disturbing turn. The detective just revealed that the victim was allegedly drowned 3 times, with one incident causing her to lose consciousness. From a legal standpoint, this isn't just assault. It borders on attempted murder. What's striking here is the timeline. The assaults allegedly spanned over 3 days, showing a clear pattern of violence and control. When juries hear details like this, they often view it as premeditation rather than a crime of passion. What do you think?
That's when the 3 drownings occurred. Third one, she passed out, was no longer conscious when she woke up. She went back to the bedroom. The defendant forced her to perform oral sex on her at that time, or on him at that time. The assault stopped at that point. After he fell asleep the next morning, he slapped her a couple times, which would have been on the 12th. Nothing else occurred on the 12th. We approached to the 13th. The 2 of them had consensual sex at that point on the 13th, after which he threatened to have her fill up the bathtub a second time, to which she was able to reach out to a colleague to call 911, and that's how the police department got involved in the matter.
Okay, what was the torture involved? Was that the strangulation or whatever?
I believe, Your Honor, that's what the prosecutor's office determined to be torture.
Okay. All right. It looks like mental pain or suffering or whatever. All this occurred in the Plymouth, Michigan?
Yes, sir. Plymouth Township.
Now, this is where the real battle begins. The bond hearing. Bond isn't just about freedom. It's about assessing risk. The defense is about to argue that McDowell deserves a chance to await trial outside of jail, but with charges this violent, prosecutors usually push for sky-high bail. Notice how his attorney is emphasizing that these are just allegations. That's a classic strategy. Plant doubt early and frame the defendant as someone who will show up for court without being a danger. Would you trust him out?
Danny McDowell, Danny Eugene McDowell.
Okay, thank you. Mr. McDowell, your attorney having waived the formal reading of the complaint and warrant, the court will enter a not guilty plea in this matter. Argument as to bond, please.
Your Honor, at this time, so we did have the opportunity to speak with Mr. McDowell. I do understand that these are very serious allegations, Your Honor. However, I would ask the court to consider that at this time, they are just that, allegations. Mr. McDowell disputes these allegations, Your Honor. He looks forward to coming to court and addressing the allegations that have been made against him. Mr. McDowell indicates that he is able to stay with his mother at his mother's home on Deacon Street in Detroit, Michigan. He indicates that he understands he is to have no contact with the complainant or with her address, Your Honor. He is 36 years old. He is not currently on probation or parole. While we do see that he has a criminal history, a felony, a previous felony conviction, it was back in 2006, Your Honor, and that was for an unarmed robbery, Your Honor. He indicates that he drives for Uber. His monthly income varies, but given his variable monthly income and his expenses, he is not able to post a monetary.
Here, the prosecution is going all in. They're asking for at least $250,000 cash bond, and for good reason. When you have a victim who might testify, witness intimidation is a real fear. McDowell's reaction in a few moments is going to prove exactly why this prosecutor is concerned. When a defendant interrupts or argues with the court, it shows a lack of control and
like we're asking for a high cash bond, at least $250,000, if not higher. If you do decide to release him, I'd at least ask that he be on a GPS tether, have no contact with the victim, not be allowed to live at the victim's house, not be on any kind of alcohol, drugs, anything like that. So to be testing for that kind of thing and then be in contact with either probation or somebody so that we can kind of monitor what's going on with him. But again, just due to the seriousness of the crimes and our fear for the victim's safety at this point, if he does get released. He did mention during when we were having him process that don't worry, none of the victims are going to come here to testify. So again, we're worried about the safety.
Come on, man. You don't lie like that, man.
Okay.
You don't have no evidence, man. You're just taking her word for it. Your Honor, he just taking her word for it. He don't have no evidence, Your Honor. And I did not say that. I said they're not going to come because it's not true.
Mr. McDowell, you have the right to remain silent. I would strongly suggest you exercise.
this is the meltdown moment. McDowell just interrupted the judge and his own attorney. That's courtroom suicide. When defendants lash out like this, judges see them as dangerous, impulsive, and incapable of following rules. From a legal standpoint, these outbursts often lead to higher bail amounts because the court believes the person is a flight risk or a threat. What's even more shocking is how personal this gets. He starts accusing the court of lying and having no evidence. If you were the judge, would you increase his bond right now?
Okay?
Yes, sir.
Thank you.
Thank you, Your Honor. And so I do think, again, if that comment was made, it could have been made for various reasons, Your Honor. And so I would ask that the court consider that these are verbal allegations that are being made at this time, and that my client has lifelong ties here, and that his previous conviction was back in 2006, Your Honor, and that somehow after 3 days there was access to there's a lot to be flushed through here in the facts, Your Honor, okay? And so I would ask that my client be given the opportunity to come to court and do just that. He understands he's to have no contact with the complainant, and I would ask that the court consider all of that, Your Honor.
All right, thank you, Ms. Medina.
Thank
The court, having heard representations of the attorney and the officer on this matter, what is very, very troubling and is indicative that Mr. McDowell cannot control his emotions and impulsive were just demonstrated. And he admitted he's very, very emotional. He responded disrespectfully not only to me, to the court, but to his attorney and who's acting in his best interest. And so, given his demonstrated impulsiveness, the court's going to adopt the recommendation of the officer, a $250,000 cash surety bond, no 10%. If he's able to post that bond, no contact with Faith Allen and no contact with the Heritage Drive apartment located in Plymouth, Michigan. Your probable cause conference date is July 27th, 9 a.m. at 35th District Court. The preliminary examination date is August 3rd, 9 a.m. Just to be clear, and just to clarify the court's ruling, the court deems Mr. McDowell a safety to the community, a safety to the party witness in this matter, and given his extended emotional outburst before the court just now.
And there it is, McDowell's temper just cost him dearly. The judge jumps from $250,000 to $500,000 and then to $1 million. This is one of the rare moments where a defendant talks themselves into a worse situation right on camera. This isn't just about money. A $1 million cash bond essentially means McDowell will stay behind bars until trial. Judges use this as both a punishment for disrespectful behavior and as a way to protect the public. What do you think was the judge? Fair here, or did McDowell's emotions seal his fate?
Okay, the court's going to change the bond to $500,000.
Wow, sir, you can change to $500,000. He's still lying. He don't have no evidence. Now it's $500,000. Make it $1 million. It don't matter. I can't post 250,000.
Okay, I'll make it $1 million then.
I can't post none of it anyway.
Okay, sir, step aside. This concludes the hearing.
Okay, Your Honor, so the final amount for the bond?
$1 million.
And is that
cash surety?
He's seen all that shit on her report, and he ain't taking none of that evidence down, man. I know what he's trying to do, man.
Your Honor, he was put back in a cell. I'm sorry about that, Your Honor.
Okay, no problem. That concludes the hearing. Thank you, officer.
This hearing was a masterclass in how courtroom behavior can make or break your case. McDowell walked in facing severe charges, but his inability to stay calm turned a $250,000 bond into a $1 million price tag, effectively ensuring he'll remain. Locked up, the judge made it clear. Emotions don't win in court, facts do. This case now moves forward with a probable cause conference on July 27th and a preliminary hearing on August 3rd. What do you think about this case? Was justice served? Or did the judge go too far with that $1 million bond? Drop your thoughts. In the comments, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns.